Let's go to social legislations. We will tackle first the maternity leave as provided under Republic Act number 11210 or the expanded Maternity Leave Act. Under Section 3 of this law, all covered female employees in government and private sector, including those in the informal economy, regardless of civil status or legitimacy of a child, shall be granted 105 days maternity leave with full pay and an option to extend for an additional 30 days without pay. Provided that in case the worker qualifies as a solo parent under the Solo Parent Act or RA 8972, the worker shall be granted an additional 15 days maternity leave with full pay. So by looking at Section 3, it is possible that the qualified employee here may have 100 days maternity leave full pay and an extension of 30 days without pay, and may avail also if the mother is a solo parent under RA 8972, she may be granted additional 15 days maternity leave with full pay. Now, who are covered employees? Female employees or covered female employees shall include those who are covered under Republic Act 11199 or the Social Security Act of 2018, more particularly Sections 9, 9-A, and 9-B. They may avail of maternity benefit under this law. Now, who are employed or who is an employed female social worker, a female worker? It refers to a female worker including domestic worker, those hired in domestic services, who perform services for an employer in which either both mental or physical efforts are used and who receives compensation for such services with their employer-employee relationship. Now, regarding the qualification, we are now going to use this law, and this maternity leave benefit for female workers can be availed regardless of civil status. All female workers in government and female members of SSS, regardless of status, shall be granted maternity leave with full pay upon compliance of the preceding section. This provided in Section 7 the implementing rules and regulations of RA 11210. So as long as you are a member of SSS, regardless of civil status, and you deliver a baby, you can avail of maternity leave under this law. The enjoyment of maternity leave cannot be deferred, but should be availed of either before or after the actual period of delivery in a continuous and uninterrupted manner not exceeding 105 days as the case may be. Maternity leave shall also be granted to female workers in instance of pregnancy, miscarriage, or emergency termination of pregnancy, regardless of frequency, provided for cases of miscarriage or emergency termination of pregnancy, a 60 days maternity leave with full pay shall be granted. Another provision of law and innovation of law is the 7-day allocation rule under Section 6 of the expanded maternity law. It provides any female worker is entitled to a maternity leave benefits provided herein, may, at her option, allocate 7 days for said benefit to the child's father, whether the same is married to the female employee, whether or not. So it doesn't matter if the father is married to the female worker. And this benefit under that section is over and above the paternity leave under Republic Act 8187. So if there is an allocation of 7 days under this law, there will be an additional paternity leave also if the father is qualified under paternity leave for another 7 days. So all in all, the father will have 14 days leave with pay. Regarding the reimbursement of paternity leave, no, under the Paternity Act of 1996 and its implementing rules, there is no mention here of reimbursement, no, to the employer of the amount that it paid to an employee who availed of his privileges under the law. However, under Section 6 of the expanded Maternity Leave Law, there is the allocation of 7 days. The implementing rules provide that in case a female worker avails of the option to allocate, the SSS shall pay her the amount of the maternity benefit corresponding to the period allocated. As applicable, the father, or in case of death or absence of capacity, the alternate caregiver shall be granted by his employer a leave with pay equivalent to a period of 1 to 7 days, which may be enjoyed either continuous or in intermittent manner, not later than the period of maternity leave availed of. This applies to absence of the father in case of death or absence or incapacity. So 3 instances: in case of death or absence of father or incapacity, the alternate caregiver may avail of this benefit. Now, what should the female worker do? The female worker shall notify if the female worker would like to avail of the allocation of 7 days to the father. The female worker shall notify her employer of her option to allocate with her application for maternity leave. The father or alternative caregiver, as the case may be, shall notify the employer concerned of his or her availment of the allocated leave and inclusive dates therefore. Thus, only when a male employee avails of the benefit under RA 11210 as allocated by the mother, can the employer ask for reimbursement from SSS. The maternity leave can be credited as combination of prenatal and postnatal leave, as long as it does not exceed 100 days, and provided that compulsory postnatal leave shall not be less than 60 days under Section 9 of the implementing rules of RA 11210. Those who avail the benefits of this expanded maternity leave, expanded maternity act, whether in the government service or private sector, shall be assured of security of tenure. This will not be the basis, the option. The exercise of this right under this law shall not be the basis for demotion or termination of employment. The transfer to a parallel position or a reassignment from one organizational unit to another in the same agency or private enterprise shall be allowed, provided that it shall not involve reduction of rank, salary, or otherwise amount to constructive dismissal. So an employee, a female employee, under the expanded Maternity Leave Act is entitled to those aforesaid mentioned. Another leave entitlement of a female employee is provided under RA 9710, otherwise known as the Expanded Magna Carta for Women. It is a special leave which granted to women employees who underwent surgery caused by gynecological disorder. Under Section 18 of the said law, a woman employee having rendered continuous aggregate employment service of at least 6 months. So for qualification purposes, the employee here must have rendered service for at least 6 months for the last 12 months, shall be entitled to a special leave benefit of 2 months with full pay based on her gross monthly compensation following surgery caused by gynecological disorder. Another leave benefit which a woman employee could be entitled to would be under Republic Act 9262 or the Anti-Violence Against Women and Their Children Act of 2004. Victims under this Act, under Section 43, shall be entitled to take a paid leave of absence up to 10 days, in addition to other paid leaves under Labor Code and Civil Service Rules and Regulations, extendable when necessity arises as specified for the protection order. So, a woman who is a victim of violence under RA 9262 may go to court and ask for protection order. If the court will issue protection order, then this leave may be extended if the protection order also is extended. Any employer who shall prejudice the right of persons under this section shall be penalized in accordance with the provision of the Labor Code and Civil Service Rules as may be applicable. And likewise, an employer who shall prejudice any person for assisting a co-employee who is a victim under this law, RA 9262, shall likewise be liable. Let's go to another social legislation, the Solo Parents Welfare Act of 2000. This is Republic Act 8972. Now, who is a solo parent? You have to qualify under Section 6, Paragraph B. So there is an enumeration here of who a solo parent is. Just to have a rundown, a solo parent is any individual falling under any of the following categories. 1. A woman who gives birth as a result of rape. 2. A parent left solo or alone with the responsibility of parenthood due to death of spouse. 3rd, a parent left solo alone or alone with the responsibility of parenthood while the spouse is detained or serving sentence for criminal conviction for at least 1 year. 4th, a parent left solo or alone with the responsibility of parenthood due to physical and mental incapacity of the spouse are certified by public medical practitioner. 5th, a parent left solo or alone with the responsibility of parenthood due to legal separation or de facto separation from spouse for at least 1 year, provided that he or she is entrusted to custody of children. 6th, parent left solo or alone with the responsibility of parenthood due to declaration of nullity of annulment of marriage as decreed by court or by church, provided that he or she is entrusted with custody of children. Parent left solo or alone with the responsibility of parenthood due to abandonment of spouse for at least 1 year. 8. Unmarried mother or father who has preferred to keep and rear his or her child or children instead of having others care for them or give them up to welfare institution. 9. Any other person who solely provides parental care and support to a child or children, provided that he or she is duly licensed as foster parent by this WD or duly appointed legal guardian by the court. In this case, the person is not related to the child or children. However, there must be a license obtained from the DSWD showing that the foster parent is accredited by DSWD, or in other scenario, when the person is appointed as legal guardian by the court. Finally, any family member who assumes responsibility of head of family as a result of death, abandonment, disappearance, or absence lasts for at least 1 year. Now let's go to rights of solo parents. One right of the solo parents would be the availment of flexible work schedule as provided in Section 6. So when you say flexible work schedule, the employee can, instead of going to work at 8 o'clock, the employee can report for work at 10 and go out at 6 just to bring the children to school. Another right of the solo parent would be right against discrimination with respect to terms and conditions of employment. And another one, the last one, is the availment of the 7-day solo parent leave. Subject to the following requirement: it should not be more than 7 days a year that the employee is a solo parent, and the employee has rendered at least 1 year of service under Section 8. Now, if you want to avail of your solo parent benefit, the requirements are as follows under Section 19. The employee has rendered at least 1 year of service, whether continuous or broken. Second, that the employee has notified her employer of the availment thereof within reasonable time period. And finally, he has presented a solo parent identification card to his employer. Now, who will issue the solo parent identification card? It can be obtained from the DSWD. Section 20 prohibits the conversion of parental leave. You cannot convert that into cash. It will defeat the purpose. If there is an existing or similar benefit under company policy or collective bargaining agreement or collective negotiation agreement, the same shall be credited as such. If the same is greater than 7 days provided for the said act, the greater benefit shall prevail. Emergency or contingency leave provided under company policy or collective bargaining agreement shall not be credited as compliance with the parental leave provided for under this act and under these rules. So that's the second social legislation, the Solo Parent Act. Let's go to Republic Act 8187, the Paternity Leave Act of 1996. Under Section 2 thereof, every married male employee in the private or public sector shall be entitled to paternity leave of 7 days with full pay for the first 4 deliveries of legitimate spouse with whom he is cohabiting. So by looking at Section 2, you'll know the requirement. It's applicable to first 4 deliveries, whether miscarriage or deliveries, and the deliveries of the legitimate spouse with whom he is cohabiting. Now let's look at the features of this law. All married employees, regardless whether they are living together physically or with the wife, because of location of work, the husband may be working far away, and regardless of employment status, shall be entitled to paternity leave benefit of 7 days with pay including allowance. So if the husband is a probationary employee or casual, whatever employment status, the husband is entitled to this paternity leave benefit. The paternity leave, as what is mentioned, applies only to first 4 deliveries or miscarriages of his legal wife. This does not apply to an illegal relationship. The male employee should notify his employer the pregnancy of his wife and her expected delivery. However, in the case of miscarriage, prior application is not required. If the benefit is not availed of, it's not convertible to cash. If there is an existing paternity leave under collective bargaining agreement or contract or a policy greater than 7 days, the greater benefit shall prevail. On the other hand, if the paternity leave is lesser than 7 days, then the employer shall adjust the existing benefit to the extent of the difference. A company policy or contract or collective bargaining agreement which provides for an emergency or contingency leave without specific provisions on paternity leave does not exempt the employer to grant full 7 days paternity leave to covered employees. Now let's go to the fourth, social legislation. It's very important. Let's go to Workmen's Compensation Act. First is this Workmen's Compensation Act gives benefit to employees who became permanently disabled or temporarily disabled or even died in connection of work. This is attached in the Social Security where you can file your claim under Workmen's Compensation Act. A very important issue here is whether or not claims from both Workmen's Compensation Act and SSS would be available, or does it mean that one precludes the other? So there is a landmark case of Benguet Consolidated Incorporated v. Social Security System, March 31, 1964. In this case, according to the appellant, when an injured employee receives any compensation under Workmen's Compensation Act, such compensation automatically precludes the employee from collecting any other benefit or compensation or privilege of whatever kind and nature arising from the same illness or injury by reason of which he was paid. However, the Supreme Court said that is not correct. According to the Supreme Court, the employee or his heirs can recover from Workmen's Compensation Act and from the SSS law. According to the Supreme Court, this is not the case, because in respect of Social Security benefits, because the law allows recovery of said benefits and does not mean double recovery against the same employer. According to the Supreme Court in that case, an action for recovery of sickness benefits under Social Security Act for the employee's compensation or employee's confinement, which is compensable under the Workmen's Compensation Law, is not a recovery against the employer for sickness benefit. The fact that the law requires sickness benefits shall be advanced by the employer is of no moment, as the obligation of the employer to advance such benefits is only to expedite payment of sickness benefit. Note that the employer is subsequently reimbursed by the system of the benefits advanced by him and the amounts fixed by law. Although the employer in the case of sickness benefits bears the burden of 20% of the benefits advanced by him, since the system reimburses only 80% thereof. The burden of 20% is imposed not as a liability because of an injury which is compensable under the Workmen's Compensation Act, but to preclude connivance in or in filing of fraudulent claims of reimbursement, which the reimbursement. This 20% of sickness benefits imposed on the employer is more the nature of administrative expense and not really compensation. So that's how the Supreme Court explained it. Further, the legislative history of Social Security Act clearly indicates that it is the legislative intention to treat Social Security benefits as entirely distinct and separate from statutory benefits provided for under the Workmen's Compensation Act. The Supreme Court again explained that the philosophy underlying the Workmen's Compensation Act is to make the payment of the benefits provided for therein as a responsibility on the industry, on the ground that it is industry which should bear the resulting death or injury of the employees engaged in the said industry. On the other hand, Social Security sickness benefits are not paid as a burden on the industry, but are paid to the members of the security as a matter of right whenever the hazards provided for by law occurs. Now, under Board Resolution number 1911-42, dated November 29, 2019, issued by the Workmen's Employees Compensation Commission. The Employees Compensation Commission. All OFWs are now covered by the said benefit. This Employees Compensation Program has been extended to land-based Filipino OFWs who are registered members of the SSS. That's November 29, 2019. And there was also an increase of daily benefit from 480 to 600 by virtue of Board Resolution number 19-08-28. dated August 29, 2019. So for familiarization, you just refer to the list of your occupational and compensable disease. However, the most important questions here are the principles as regards compensability. First, the rule on compensability. When is it compensable? If the illness is found of those enumerated, we don't have a problem, because by law, it is really compensable based on the enumeration. So in the case of Flor G. Dayo versus Status Marine Corporation, a maritime corporation, and or NAFTO Trade Shipping Commercial SA, January 21, 2015, the Supreme Court said that it is not necessary that the nature of employment to be the sole and the only reason for the illness suffered by the seafarer. It is sufficient that there is reasonable linkage between the disease suffered by the employee and his work to lead to a reasonable mind to conclude that his work may have contributed to the establishment or the very least aggravation of the pre-existing condition he might have had. This is the rule of compensability, or the causal connection rule. In another case of Rizaldi versus Quitoriano versus Gibson's Maritime Incorporated and Maria Teresa Gutay, January 21, 2010, according to Supreme Court, again, this is a relevant rule on total disability for it to be compensable. According to Supreme Court, total disability does not require that the employee be absolutely disabled or totally paralyzed. What is necessary is that the injury must be such that the employee cannot pursue his usual work and earn therefrom. Citing the case of Austria vs. Court of Appeals, August 12, 2002. Total disability is considered permanent if it lasts continuously for more than 120 days. Citing the case of Crystal Shipping Corporation versus Natividad, December 17, 1999. Regarding post-employment medical certification, according to Supreme Court, this is necessary if it is contained in the contract of employment. So for the employee to avail of the benefit, the employee must undergo what we call the post-employment medical examination conducted by the company physician. Without a post-medical examination or its equivalent, to show that the disease for which the seaman died or was contracted during his employment, or that his working condition increased the risk of contracting the ailment, that the disease or the respondent company shall not be liable for the death or for death compensation. Let's go to the requisites of compensability, therefore. In the case of Leones Navigation Company Incorporated versus Catalino Villamater, March 3, 2010, for an occupational disease and the resulting disability or death to be compensable, all the following conditions must be present. 1. The seafarer's work must involve the risk described therein. Second, the disease was contracted as a result of seafarer's exposure to the described risk, and the disease was contracted within the period of exposure under such other factors necessary to contract it. Lastly, there was no notorious negligence on the part of the seafarer. So in this case, the gallstone the Supreme Court cited that there was a basis for the colon cancer because Villamater here, the diet of Villamater on board was rich in cholesterol. So there was a connection that this was aggravated. Although it is hereditary, but there was this dietary factor that was observed with the Supreme Court, so therefore it became compensable. Okay, let's go to the Republic Act 9994, no? Amending RA 7432, otherwise the Senior Citizens Act. The reason why I'm including this one, because there may be employees who are 60 years old but below 65. So their entitlement under this law would be exemption from payment of individual income tax. Who are for employees who are senior citizens and receiving minimum wage. So they are exempted also. In order to avail of the benefit, then there must be presentation of proof of age, either of the following: the senior citizen's ID, the passport, or other documents to establish the age of the employee. Under the amendment of RA 994, which is the Republic Act 10645, it provides that these senior citizens are entitled to PhilHealth as mandatory coverage. So once you reach the age of 60, you are automatically covered by PhilHealth. Let's go to the Portability Law, because this is very popular in bar examination. This applies to members of SSS and GSIS. An employee will transfer from private to public and public to private. And if they want to avail of the retirement because he is not qualified from the other benefit, so you will use the Totalization Rule, no? Which provides that all creditable services or periods of contribution made continuously or in the aggregate of the work or in the aggregate of a worker under the either of the sectors referring to private or public shall be added up and considered for purposes of eligibility and computation of benefit. So if you transfer from government to private and you work only for 10 years in private, and you want to avail of the benefit of SSS, then there will be totalization of your creditable services for you to qualify under the SSS retirement benefit. However, this only applies if the worker does not qualify to one, no, or to the GSIS or SSS. However, if the worker qualifies for benefits in both systems, then the totalization will definitely not apply. Okay. The last one would be Republic Act 1158, or the Act strengthening the compliance with occupational safety and health standards and providing penalties thereof. The coverage it shall apply to establishments, projects, sites, including Philippine Economic Zone Authority, establishments and other places where work is being undertaken, or in all other places where work is being undertaken in all branches of economic activity except public sector. So we have to look at DO 198, the implementing rules. Under this rule, Section 2, this applies to establishments located inside PESA, utilities engaged in air, sea, and land transportation, and industries such as mining, fishing, construction, agriculture, and maritime. This rule shall also cover contractors and subcontractors, including those engaged in the projects of public sector. This rule does not apply to the private sector, public sector, such as national government agencies, government-owned corporation with original charter. So what are the duties of every employer? So it's provided in Section 4 of the law. So every employer, contractor, or subcontractor, if any, or any person who manages, controls, or supervises the work being undertaken, shall furnish the workers a place of employment free from hazardous conditions that are causing or likely to cause death, illness, or physical harm to workers. Shall give complete job safety instructions, orientation to all workers, especially to those entering the job for the first time, including those relating to familiarization with their work environment. Shall inform the workers of the hazards associated with their work, health risks involved, or to which they are exposed to, preventive measures to eliminate or minimize the risk, and steps to be undertaken in cases of emergency. The employer shall use only approved devices and equipment for the workplace. The employer shall comply with the occupational safety and health standards, including training, medical examinations, and where necessary, provisions of protective and safety devices as personal protective equipment and machine guards. The employer shall also allow workers and their safety and health representatives to participate actively in the process of organizing, planning, implementing, and evaluating the safety and health programs to improve safety and health of workers. And lastly, the employer shall provide where necessary for measures to deal with emergencies and accidents, including first aid arrangement. What are the rights of workers under this law? More specifically, the worker has the right to know. What do you mean by this? The right to safety and health at work shall be guaranteed. All workers shall be appropriately informed by the employer about all types of hazards in the workplace, provided access to training and education on chemical safety, electrical safety, and mechanical safety, and ergonomical safety. The second right of the employer is the right to refuse unsafe work. The worker has the right of refusal to work without threat or reprisal from employer if, as determined by the DOLE, an imminent danger situation exists in the workplace that may result in illness, injury, or death, or corrective actions to eliminate the danger have not been undertaken by the employer. Another one, the workers have the right to report accidents. Workers and their representatives shall have the right to report accidents, dangerous occurrences, and hazards to the employer, to the DOLE, and to other concerned government agencies exercising jurisdiction as a competent authority in a specific industry economic activity. Then workers also have the right to personal protective equipment, PPEs. Every employer, contractor, subcontractor, if any, shall provide his workers free of charge protective equipment for their eyes, face, hands, and feet, and free and lifeline, safety belt or harnesses, etc. There is the principle of joint and solidary liability. The employer, project owner, general contractor, contractor, subcontractor, if any, and any person who manages, controls, or supervises the work being undertaken shall be jointly and severally liable for compliance with this act. And under Section 22 of the Department Order 198, there is that visitorial power of the Secretary of Labor. Under Section 22. Section 22 of the law, not IRR. The visitorial enforcement power of DOLE is applicable here just to enforce safety standards.